morning, good afternoon, everybody. Thank you very much, Benoit, for your kind introduction. And I would like also to take this opportunity to thank IPKey China, the European Commission, and also the China Anti-Infringement and Anti-Counterfeit Innovation Strategic Alliance for the kind invitation. And also I would like to welcome the future entry into force of the EU-China RGI agreement, because I think it's really symbolic, it's crucial agreement. It has been mentioned by the previous speakers, the EU and China are probably two of the most important actors internationally for geographical indications, with more than 3,000 GIs recognized in Europe, more than 5,000 GIs recognized in China. So I think this agreement, which provides solid protection, is going to be very important and will set a model for future agreements. And also, I joined the previous speakers in saying that enforcement will be crucial to ensure that the actual protection and the solid protection of GIs from both jurisdictions. So I will also address the question raised probably at the end of my presentation. I will start by sharing my screen. So just a little bit of a summary of my presentation. I will say a few words about Origin. Thank you also, Benoit, for mentioning it. I will speak about some data concerning e-commerce, which will give us the idea of the strategic importance and also an idea of the risks. In fact, in terms of challenges, we see at Origin two main problems, with e-commerce, the growing risks of counterfeiting and infringements, and then the problem of internet domain names and cyber squatting. Just a few words, as you said, Origin is a global alliance of GIs. We have a huge number of groups from all over the world representing GIs. Just to tell you that in some countries also we have IP offices or other public authorities as members. For instance, in China, we have the China National Institute of Standardization, which helps us to be in touch with local GIs. And for instance, we have also, thanks to them in our network, Longjingti and Pingu De Tao, the famous beach. Also in Cambodia, we have the local IP office, which allows us to be in touch with all the local producers. And but let's enter a little bit into the topic of today. So e-commerce, the data will show us the opportunities, as been mentioned by John as well. I've looked at the eMarketer trends, forecasts, and statistics. And in 2020, we will have almost 4 trillion in global e-commerce retail sales, which is a huge increase compared to the previous year. In terms of area, the Asia Pacific is the leading area with 42.3%, followed by North America and Europe in the third position. More specifically, China is the largest e-commerce market in the world. And if we speak in terms of agriculture, according to eMarketer, in 2025, the online retail sales will represent between 15 and 20% of the overall worldwide sale of the food and drink industry. So this shows like the importance, the crucial importance that e-commerce is having for our purchasing behaviors, and in particular also for the purchase of food and drinks. And this will grow and grow. It represents for sure an opportunity for GIs because they can be known, and we know that internationally all the statistics show how consumers are looking for authentic stories, are looking for original products that have an impact also on sustainability. They want to know the impact on local communities, how local producers get in terms of added value share. So this is an opportunity also for small GIs to get known, and the online market platforms, some of them are Chinese, and it's really a big business. And also recently, a few years ago, Amazon bought Whole Foods, a retailer in the US that is really focused on specialty and quality food. So this is opening up really huge opportunities for GIs. At the same time, the challenges are there. Also, they have been mentioned. classical cases of counterfeiting. The most difficult cases to deal with of GI infringements, which include evocations, protected GI names used in translations, use of GIs as ingredient. So we see this as a trend, is also a growing trend, because infringers have understood that not only in Europe, but in many jurisdictions around the world, using GI names is not allowed. So they try to test the system, let's say, using names that can evoke. Some examples have been, very good examples have been shown by George previously. And this is a big issue, especially for GI groups, and I would say small GI groups. Let's not forget that both in Europe, in China, and internationally, the majority of GI groups are very small. They have limited financial capacities. So they have to understand, they don't have the knowledge. They don't know the applicable rules when there are e-commerce transactions. They don't have resources to monitor the markets. They cannot pay companies that do the monitoring. And also, even if an infringement is detected, they don't have the money to enforce, to go to a tribunal and pay lawyers in a different jurisdiction, sometimes also problem of language. And there is a big issue also for consumers, because if you buy a product which does not correspond to the product specification, to the original GI, you might lose trust vis-a-vis the platform, vis-a-vis the product, and also the product, the GI, might suffer a reduction, and its reputation will be diminished. Some examples, here again, I've chosen some, is not to point out any platform, just the fact that there are people that try to basically benefit from the reputation. This was a case of champagne type Espagnol, tipo Espagnol. Another case of Parmigiano Reggiano, Parmesan Italian cheese, an evocation. So it's not really important to, these are private economic actors that try to sell those products. And the majority of online platforms, including Alibaba, including Amazon, they have some instruments, some opportunities for right holders to claim, to mention, to point out the infringement of an IP right in general. And so as geographical indications are part of those IP rights, GI owners, GI beneficiaries can use those mechanisms in order to basically request the removal from the marketplace of the products. We will see the presentation of Bartolomeo specifically on how national governments also can help. Because again, I come back to my point of small GIs. Again, established GIs, they can use those platforms and enforcement mechanisms that they provide, but there are some small GIs that cannot do that. So that's why I think it's important at Origin to encourage the MOU and other cooperation agreements that have been signed by, for instance, the Ministry of Agriculture of Italy, by the Ministry of Agriculture of Spain, with a number of platforms, in order to centralize the system and make sure that each time that an infringement is detected online in those platforms, they can request the removal, showing that there is an IP right and showing that they represent the GI beneficiaries. Because as we all know, GIs, it's a community right in which also the states has an important role. One issue that I would like to mention in this respect is that in those agreements, it's important to look at the applicable law, because normally products are to be shipped somewhere. And of course, if you say, if the product is to be shipped in the European Union, so we apply the agreement, we request the removal of the product. I think it's important, since the European Union and now also China is signing bilateral agreements to the protection of GIs, is important also to take into account third markets, where all the jurisdictions where a given GI is protected. So let's say if a European GI sold in an e-commerce platform is to be shipped in China after the entry into force of the agreements, or to be shipped in Peru, where there is already a bilateral agreement. If the GI is in the list, I think it's important also to give the possibility to the right holder to request the removal of that product, the infringing product, from the platform. This is, our position with respect to the first challenge. Now, let's also speak a little bit about the second challenge, the internet domain names, which is also important and is also related to counterfeiting and to the possibility of selling infringing products on the net. So just to put it into context, what's an internet domain name? Normally, a website is composed by the World Wide Web, www. Take here the example of the website of origin, and then you have a first level of the domain, which is after the dot, and can be a generic top-level domain as .com, .int, .org, or can be a country code top-level domains managed by national authorities at the national level, like the .cn. And then you have the second level domain, which is basically before the dot. And this is assigned by authorized private companies around the world on the principle of first come, first served. Okay, so we were the first one that registered origin gi.com, so that's why we got it. In terms of generic top-level domains, until 2012, we had some 25, the most known, I would say, and used, .com, .coop, .info, .int, .org. But then after 2012, the private company IPKey, which manages basically this aspect of the internet, authorized more than 1,000 new generic top-level domains and gave the possibility to companies that paid, actually, because it was not for free on top of that, that bought basically those strings to basically sell second-level domains with using those strings. And as you can see, some of them, like the .food, the .wine, .vin, .coffee, .organic, could be quite appealing for people that want to sell food products, including GIs. If we think that, for instance, in Europe, that the majority of wine produced in Europe is under GI. So if you have a .wine website, you would expect probably that that website will sell original GIs. So this has increased dramatically the risks of cyber squatting. Okay, because now you have more than 1,000 domains to look and to monitor. And just to give you an example, basically cyber squatting is when the registration of a second level domain, so before the dot, is in conflict with an intellectual property right, mainly GIs and trademarks. So this was a Dutch tequila. So basically website, it was .Netherlands. So what can we do when there is someone that registers a second level domain in conflict with the GI? We have to distinguish because generic top level domains are basically applying the Uniform Dispute Resolution Policy. All the 1,000 plus generic top level domains are bound to this policy. And this policy was basically finalized within IPKey, this private company that manages, the attribution of domain names, which is also a problem of governance, because we might ask ourselves why a private company is able to do this, and is implemented by authorized dispute resolution centers around the world, including the World Intellectual Property Organization, which applies a rule which has been established. And that rule, this policy, in its rule 3B7, basically says that only trademarks are considered a valid title to activate the UDRP. This means that if you have a conflict between a second level domain and a GI, if your GI is not also registered somewhere as a trademark, can be any jurisdiction around the world, you cannot activate this mechanisms, which means you cannot basically stop the website, the existence of that website. And the famous case concerns the geographical indication, the appellation Champagne, that wanted to fight the registration of a champagne.uk.co, and that was the attempt to basically stop that website, terminate that website, or basically obtain the use of that website was prevented because the claim was purely based on the geographical indication. Then you have country code, top-level domains, and then every country has a different policy. Some consider GI as a valid title to activate curative mechanisms. Some others do not. But we see an increasing number, that either mention IP in general, so under IP GIs are part of it, or mention GIs explicitly. So that's something very important. And also, there is another interesting evolution, not just the country code top-level domains, is also the evolution of the two specific strings I mentioned previously, .wine and .van. Because when they were authorized, basically, the private company that obtained the ownership, in inverted comma, of these two strings, accepted under the pressure of the wine industry, the international wine industry, because it was Europe, there was in the US, Australian wine producers, they all joined forces, and basically they obtained, in a private agreement, also the possibility for to give some sort of priorities to GI beneficiaries to register a second-level domain .wine.van, but also to have some curative mechanisms, which are not publicly disclosed because it's a private agreement, but it exists, so it's a good precedent. Also, the position of Origin on this. What can we do to improve the situation? Of course, there is ideally a reform of the UDRP, in which, on top, parallel to trademarks, also GIs would be considered a valid title to basically activate the mechanism. And there is a working group in IPKey. We are quite isolated, unfortunately. It would be interesting also to have more and more actors joining this working group to raise the voice of GIs, because it's not, I tell you, it's not evident. Probably a reform of the IPKey governance in general to make it more respondent to basically what is in the international intellectual property law. I think the internet has to be bound also by international law, and now GIs, as been mentioned, TRIPS agreement, Geneva Act, bilateral agreements, GIs are IP. There is no doubt about that. But also the possibility to include the issue of cybersquatting and the fight against cybersquatting in bilateral agreements, because this will, the possibility of protecting GIs in all country code top-level domains under the pressure of bilateral agreements, this could basically make de facto possible to include it also in the generic top-level domains. So that's why Origin, in this case, in cooperation with the European Federation of Origin Wine, propose a clause to the European Commission, but it's a clause that can be used by all policymakers signing bilateral agreements on GIs. So having a specific clause also to deal with the case of cybersquatting, at least at the country code level. So because if we can demonstrate that all country code protect GIs, then there is no obstacle for generic top-level domains to do the same, because it's possible, it's feasible, and basically there is no risk, because you have a right, you have a beneficiary, a right holder, so you just have to apply the existing rules on that. So this is, again, I insist, is very important because it's very much linked to the problem of counterfeiting and infringements. Because when you have a website which has a string like .food, .organic, .coffee, .wine, and the name of a geographical indication as second-level domain, I think consumers and people buying on the internet, they expect to have original products, and the problem is that not all the time those strings, those domain names basically go to the legitimate GI owner. So we have to improve that. So in conclusion, three main messages from our side. First of all, again, we welcome the EU-China bilateral agreement, and we praise and we thank all the authorities in Europe and in China that have been working for this important result. It's a crucial agreement, and we believe that more and more agreements will follow this path. And then, of course, in terms of online protection for GIs, there is a lot to do. The problem of e-commerce and the problem of internet domain names are, in our view, the most relevant. And again, cooperation, the possibility also to improve future agreements in order to tackle the problem of cyber squatting, I think is something to take into account. With this, I thank you all. I don't know if there are questions for me, but if you want, I can also say my view under the supervision, of course, of the European Commission. But on the previous question, I think the European regulations require a group to apply for a geographical indication. So a group means an association of producers and transformers, depending on the case. So I think in the European Union, it wouldn't be possible to obtain a GI by a single company, by itself. Thank you so much, and I'm available for questions.
Thank you very much, Massimo. There is a question that I will maybe leave for a bit later, because I think it might be a bit more topical for questions of an EU-China investment and trade agreement, maybe less on the GI. I maybe invite the speaker from the GI to look at the question and maybe tackle it later. I have an immediate question, which is very specific to top-level domains that you mentioned, and domain protection, which I think would be of interest to be touched now, because it is very specific to your presentation, I believe. From your experience and what you've seen, is this something that is really a challenge, for instance, for what Europe or China are concerned, a challenge on the market, or is it maybe more a challenge that would be specific for other markets that don't necessarily have a system of geographical indication protection, and where then where the possibility of using GI as trade names for opposing the use of the domain name or the top-level domain would be relevant?
I think it could become a problem, because every country code has a different have different rules, and sometimes, as I said, they mention IP in general. So someone might argue, no, under IP, GIs has not been specifically mentioned. So I think as a recommendation for future work in the EU and in China is to look at the .eu already considers GIs, but I think it's important from the European perspective to look at every single country code of member states, and for China to look at the .cn and make sure that GIs are explicitly mentioned as a title. And I think with that will be enough, because once you have the rules, then it's up to the GI groups to do the work in case there is a problem. And given the high importance attached by both jurisdictions to GIs, symbolized by this agreement, I think this further step, it's something that can be done with no major problem.
Good morning or good afternoon, because there is a difference between the daylight. I would like IPKey China, the EU Commission, and DG Agri and the UIPO for this very, very interesting meeting, and for the invitation. I would like to present, from my point of view, of course, a very interesting example of a GI protection performed by an EU enforcement authority, which is my administration, the IPKey-RF. Probably the IPKey-RF is one of the most important enforcement authority in the European Union. due to the fact that the ICQRF performs on a yearly basis more than 50,000 controls, and among them more than 13,000 controls regarding geographic indications. And over the years, we have also implemented a lot of very good and fruitful cooperations among several member states of EU member states or enforcement authorities, as well as also with different enforcement authorities of third countries. And last but not least, we have also implemented several memorandum of understandings with some of the most important e-commerce marketplaces in the world. Let me briefly present. The administration is a specific department of the Ministry of Agricultural, Food and Forestry Policies of Italy, and the ICQRF is engaged in several responsibilities regarding in general official controls for the protection of agri-foodstuffs, but in the specific field of geographical indications, we have also a lot of other responsibilities, such as imposing monetary and other sanctions as a result of inspections and analysis findings. The ICQRF also authorizes private and public control bodies for the certification of foodstuffs as PDOs and or PGI responsibility, because in Italy and in many EU countries, the certification of an agro-foodstuff as a PDO or a PGI is delegated from the competent authority to one or more private or public control bodies, previously accredited according to ISO standard. But the ICQRF is also in the position to authorize, and this is very, very important, PDO and PGI producer groups to carry out market surveillance over their PDO and PGI products. And this is a very good examples of a strengthened cooperation and the producer groups to strengthen GI protection, not only in Italy, but worldwide. Last but not least, we have also the power to supervise the aforementioned, the ICQRF has 29 local inspection units, more than 700 qualified officials, who are inspectors, laboratory technicians, lawyers, and so on, and specific units dedicated to specific activities. For example, the Central Investigation Unit, the specific GI cooperation unit with the other member states authorities, and the food labeling units. In 2019, the ICQRF performed more than 55,000 controls. And why the work of the ICQRF is so important for the protection of the Italian GIs worldwide? Because GIs, the Italian GIs, represent almost the 21% of the Italian agro-food production value. And their value in terms of sales value was in 2019 equal to 60.2 billion euros. This is why it's so important to protect our GI basket, because GIs are, of course, our tradition, our emotion, but mainly our money, our turnover, domestic turnover. The main tools set out by the ICQRF to protect GIs are based on domestic controls, on mechanism of cooperation among with the other member states enforcement authority, through a strong cooperation with the European Union by developing the bilateral agreements, through direct cooperations with other third countries in the framework of bilateral agreements, but also with third countries with which the European Union has not implemented yet any bilateral agreements, using, for example, direct cooperation in order to implement GI protections in countries such as Russia, the Russian Federation, by using as a main protection tool, for example, the protection of for example, the Russian consumers from not being misled in case of serious infringement regarding the selling of GI, of the Italian GIs in that country. Also through several web cooperation. At the national level, we have several protection tools regarding the protection of geographical indications. First of all, we have two main important administrative laws protecting GIs against, for example, standards non-compliances, misuses, evocation, imitations, misleading information, and commercial and illegal commercial practices. And most importantly, also we can perform criminal investigations by using our criminal code. At the domestic level, according to our 2019 reports, the ICQRF has performed more than 13,000 controls for the protection of geographic indications, both for wines and agro-foodstuffs. And at EU level, through mechanisms of cooperation among member states, we have implemented all the EU GI tools for the protection, which means the regulation for the protection of GI wines, GI agro-foodstuffs, GI spirit drinks, GI aromatized wines, and the general regulation on official controls, the regulation 625 of 2017. As for the mechanisms of cooperation among member states for wine, GI wine products, agro-foodstuffs, spirit drinks, and so on, the ICQRF is the liaison and ex-officio authority for Italy, which is engaged in exchanging reports of cooperation with the other enforcement authority. This is our current network of cooperation inside the European Union, very, very huge, of course. And we are also using the new mechanism of cooperation set by the regulation on official controls through two different lines. By using the AAC system and the food fraud network to counter specific and serious infringements. As regards the cooperation with the European Union, since 2014, we have been developing a very close cooperation with several EU services, EU Commission services, by using such very important protection tools. So we have implemented several actions to protect our geographical indications in some third countries, as previously said, not only with with some third countries with which the EU has implemented a bilateral agreements, but also with other third countries with which the European Union is agreements or not yet. And I can assure you that by using the bilateral agreements is a very important key to not only protect, but also spread knowledge about our geographical indications in world. There is another important message I would like to give you. The job performed by the IPKey RF by using several protection tools is not only performed offline by arranging inspections on the field, but for us now there is no difference between controls performed online and offline, because controls, the playground of controls now fully includes online market, because online market is a very huge piece of the GI markets worldwide. Another very important memorandum of understanding we implemented in 2011 was with the USTD for the protection of our GI wines, but in the framework of the agreement, 2005 agreement, between the UA for the mutual recognition of our GI wines. As far as the web cooperation is concerned, it's no use mentioning the importance and the huge impact of the e-commerce in the world. I just mentioned some figures regarding the e-commerce turnover worldwide in 2018. Equal to $1.84 trillion. So this is the main explanation why it's so important to protect online our PIs. Of course, the same impact, the same huge impact regards also the European Union with more than 600 billion euros. And in the European Union, the UK, France, and Germany are the most important markets for agro-foodstuffs in general and for DIs. And this is why we focused our attention in dealing with our e-commerce controls. Also the level of e-commerce online. Okay, we have arranged e-commerce controls by pinpointing our attention to different level of controls, which means to control internet service providers, which means simply private websites, and in doing so at the international level and at EU level, we usually ask the intervention of the other enforcement authorities in order to counter some GI infringements, and by arranging specific memorandum of understanding with the most important e-commerce platforms in the world, such as eBay, Alibaba, Amazon. We are having also contact with Rakuten, with Facebook, because also social media are developing an important platforms for the advertisement and selling of GIs to perform such kind of cooperations with e-commerce platforms. At EU level, we have used the legal tool regarding the e-commerce directive 2000/31, which states that if an internet hosting provider doesn't want to be blamed for any legal activity or advertisements or any legal information regarding GIs or whatsoever, he must promptly act in removing any infringement. And this was the main tool we have used to convince, to smoothly convince such online hosting providers to cooperate with us in the virtual territory of the European Union, of course. In the virtual territory worldwide, outside the European Union, we, through such memorandum of understanding, have convinced eBay, Alibaba, and Amazon to take down any infringement regarding our DIs by using, for example, as legal tools, the bilateral agreements, but also by using specific labeling legislation for each virtual country. The result was successful. To be more precise, the cooperation with eBay, Alibaba, Amazon, and of course many other internet hosting providers is performed through several takedown systems. Takedown systems set up by each and every e-commerce platform. For example, for eBay, there is the Vero takedown system. For Alibaba, there is the AliProtect system. As for Alibaba, we have several different kind of cooperation, because Alibaba is a very giant actor. So there are many platforms under the responsibility and the management of Alibaba. And to give my special thanks to the European Union and the Chinese government for the recent bilateral agreement 100 versus 100, I want to mention a particular cooperation with Alibaba through by using the previous 10 versus 10 agreement between the EU and China, because thanks to that bilateral agreement, the previous bilateral agreement, we were able to convince Alibaba in China to take down several websites illegally marketing, for example, fake Parma Ham, because Parma Ham was protected by the Chinese authority in China by using the former 10 versus 10 bilateral agreement. So now we can count on a new, very large bilateral agreements, and so we can mutually extend the protection of our geography. Some example, some figures, sorry. In less than 6 years, considering all the international controls, which means through the cooperation among member states enforcement authorities, e-commerce marketplaces, through the labeling web cooperation, and so on and so forth, we have been able to perform more than 4,000 controls on the web, which means a very huge pack of controls. And the most important message I would like to give you now is that performing online controls costs zero euro, $0, yuan, and so on. So it's very fruitful, it's very efficient, it's very effective to set up such kind of controls, because you can reach almost any corner of our world by simply searching some illegal promotion, illegal selling online in every part of our world. Some pivotal examples regarding our takedown actions. For example, this fake Parmesan cheese promoted on Alibaba powder, of course. Fake Gorgonzola blue cheese promoted and sold on several EU websites. Fake Prosecco on tap sold in the United Kingdom. Several fake wine promoted as Prosecco. And a very interesting example of cooperation in countering the illegal trans-border marketing of Prosecco coming from Ukraine into the European Union. This was a very huge and extensive control implemented 2 years ago, which involved 4 customs agencies of the European Union and 20 enforcement authorities, just to mention the importance of cooperating among other actors. We have also countered fake, for example, fake wine kits promoted as delicious GI wines, and the result was that on the website of this seller, the guy published this message: "Keep calm, the Italian government is watching you." Okay, some other example of fake and evoking or misleading information regarding GI products from Armenia to Russia. And that's it. Some very delicious Prosecco tips and Prosecco cheese. So just to conclude, we are very, very proud about the job performed since now, but we are not satisfied because we want to promote and to establish network of cooperation, and the intention of my administration, the IPKey, in the framework of this new agreement between the EU 100 versus 100, is to set up a direct memorandum of understanding with the main Chinese enforcement authority in order to streamline between our countries. Thank you very much for your attention, and I'm absolutely available for any question you want to put me. Thank you.